Okay, standard 4.05 is about disclosure. So under standard 4.05, we have two substandard, 4.05A on consent for disclosure and 4.05B, okay, law mandated disclosure. So this standard 4.05 outlines when and how we may be able to share confidential information. So these standards balances two ethical priorities in psychological practice. Okay, one, protecting client privacy as well as at the same time fulfilling professional, legal and safety obligations. Okay, as an IO, as a practitioner IO psychologist, so we have to balance both of these this important aspect. So this standard specifies circumstances in which disclosure of confidential information is permitted, okay, with or without the consent of our client. And this standard also establishes the limits, okay, on the scope of what to what extent we can disclose confidential information. Okay, standard 4.05A. Okay, psychologists may disclose confidential information with the appropriate consent of the organizational client, the individual client, or another legal authorized or another legally authorized person on behalf of the client unless prohibited by law. Okay, so this substandard 4.05A, this basically state that we may disclose confidential information only when our client gives appropriate permission. Okay, our client or other authorized party. Okay, unless law prohibits those kind of sharing. So this means that psychologists must first and foremost obtain informed consent for the release of the confidential information. And secondly, we must ensure that the consent is voluntary. It's not by force. Okay, this consent is voluntary, specific, as well as documented. Okay, we cannot say that he said this or he said that. Okay, it must be in some kind of documentation. And then we share our information only with the identified recipients. Okay, we cannot share it with others. So all of these with the consent of our client. So example in this case, we when provide treatment, okay, providing treatment summaries to another clinicians at the client request. Okay, examples when we involve third-party service provider, or we collaborate with service provider who offer services such as for mental health and etc. So we provide those information for them to come out with a proper treatment plan. And then another examples, we share assessment results. Okay, assessment result with parents, for example, for clients, okay, for legal guardian and etc. Another examples, we send reports to employers, okay, maybe some case to insurance company. So in this regard, the emphasis is on our client autonomy, okay, whereby we basically uphold their rights. Okay, individuals have the rights to decide who receive their personal information. Okay, so that is what are required by standard 4.05A. Whenever we want to share confidential information, we must get consent from the client or the patient. Secondly, what happens if we do not have the consent? Okay, 4.05B basically discuss about this. Okay, psychologists disclose, okay, confidential information without the consent of the individuals only as mandated by law. Okay, or where permitted by law for a valid purpose. Okay, what are these valid purpose? One, provide needed professional services. Okay, two, obtain appropriate professional consultation. Three, protect the client. Okay, they protect the psychologist or protect others from harm. Okay, you don't know what you're going to gather from the session. Sometimes it's a threat, okay, on their safety, okay, on people who are involved. So you need to disclose the information. As well as lastly, maybe obtain payment, okay, for services from a client or patient who failed to do so. So in which instance of disclosure is limited to limited to the minimum that is necessary to achieve the purpose. Okay, we should not overexpose or over disclose the confidential information of our client. Okay, only just to achieve these four goals. So this 4.05b basically clarifies to us limited, okay, it's limited but legally recognized circumstances situation where we may disclose confidential information even without the consent, okay, even without the agreement of our client. Okay, this situation generally arise when the psychologist must fulfill another ethical or legal duty. So in this case, disclosure without consent is allowed only, like I mentioned just now, stated in the standards when mandated by law. Okay, example mandated by law here include the court orders, okay, mandatory reporting of child or elder abuse or any kind of abuse, okay, duty to warn or protect laws. Okay, sometimes you discover that someone so angry towards others, so they may hurt, okay, themselves, okay, they may attack them, okay, in one way or another, and then you have the duty to warn. And secondly, when permitted by law for a valid purpose, okay, this valid purpose have many different interpretations, okay, among others, okay, providing necessary professional service. Okay, examples, consulting with another service provider to improve treatment quality. Okay, but here, of course, you have to really specify with a legal officer, with ethics officer on the appropriateness to what extent that you can discuss, you can expose the information. Okay, and another examples of valid purpose, obtaining professional consultation. Okay, consultation promotes competent and ethical clinical decision, but information shared in this case must be carefully limited. Okay, we just basically wants to improve, okay, the treatment plan and etc. And another examples of valid purpose is protecting the client, okay, protecting psychologists or protecting others from harm. Okay, in the case when our informant, our client, our patients demonstrate, okay, threat to safety and health. So disclosure may be necessary when the client poses a serious risk of violence or self-harm. And lastly, I think in many cases you might also experience this, okay, obtaining payment for services. So information may be shared with insurers, with collection entities, with police department, enforcement officer, for example. But in this case, only minimal details required for reimbursement should be disclosed. Okay, not so much. So across these examples, psychologists must limit disclosure to only the information necessary to fulfill their purpose. Okay, we should not overexpose or ever share informations about the client. So these two substandard, okay, 4.05 A and B, okay, basically the implication in our practice, whenever we want to engage in service, okay, in treatment, in intervention, we must always explain confidentiality, okay, the limits of confidentiality, okay, early on, okay, on the outset. Okay, before we start, okay, our service, we must establish this. Okay, when we sign our contract, we must establish this. What are the confidential informations? What are the limits of this confidentiality? Okay, as well as whenever involved about informed consent, private and confidential sensitive information, we need to document, okay, the rationale of keeping those information, asking those information, as well as if it's come to that circumstances, disclose those information to others. Who are the party who might be receiving those kind of information? As well as we need to consult with colleague, okay, other IO psychologists, other experienced consultants, attorneys, when the circumstances requires us to share private and confidential information. Okay, at the same time, when we talk about limits of confidentiality, disclosure of confidential information, we need to first and foremost strive to obtain consent whenever possible. I know that in cases whereby our client refused to pay, they no longer entertained, okay, our communication, our text, our call, and etc. Okay, as well as we need to use the least invasive disclosure method. Okay, so bear in mind, nowadays people like to viral, okay, the term used here, would like to disclose information in public through social media and etc. Okay, please do not result into this case, this kind of situation whereby this might be considered as invasive method. Okay, and lastly, okay, whenever, because when you involve with this kind of dispute with your client, for example, with people who are engaged in a situation that may force you to disclose this information, you need to always reassess the decision. Okay, why? Because it may evolve. Okay, the situation may evolve whereby they agree to oblige. Okay, they agree to pay, or they no longer show harm to themselves or to others, or maybe they already come to the age whereby they already legally able to provide their own consent rather than to have to depend to their legal guardians or parents. Okay, we have to remember that misuse of disclosure, okay, when we basically try to use these kinds of terms or condition in our contract, the misuse of disclosure authority can permanently damage trust, okay, can permanently create legal risks and endanger our client welfare. Okay, on the other hand, okay, conversely, failure to disclose also may result into this kind of risk. Okay, can lead to harm and may lead to ethical violation, especially if legally required us to disclose information or the court order us to disclose the information. So in a nutshell, these two substandard, okay, standard 4.05A and standard 4.05B, this standard ensure us that confidentiality remain a default expectation. So basically, when we in this kind of professional services, our client, people who engage with us, who involve in our services, they expect that we fulfill confidentiality expectation, where we are going to keep their secrets, okay, their confidential, private, sensitive information, and without disclosing to another party. But at the same times, this standard remains remains that we protect this confidential expectation. But at the same time, this standard recognize that ethical practice sometimes require disclosure. Okay, it's not unethical, but the ethical practice. It provides us psychologists with a structured and legally informed approach to balancing between privacy with protection, balancing accountability, and balancing the care of our client. Okay, next, standard 4.06 under privacy and confidentiality. Okay, standard 4.06 on consultation. So this standard focuses on how psychologists should ethically handle confidential information when seeking consultation from colleague. Consultation in this case is a standard and often essential part of competent psychological practice. But in order to do so, it must be conducted in a way that protects client privacy and aligns with the principle of informed consent and confidentiality. So in this case, okay, if you recall what we have discussed in standard 2 on competence, in many cases, sometimes the required services from our client or our potential clients is not necessarily our field of expertise. Okay, sometimes we have to engage with other consultants, we have to engage with experienced consultants, subject matter expert, professors, for example, on how to best serve our client. Okay, it may involve treatment planning, intervention, and etc. So in that case, in maybe unavoidable circumstances, we have to share confidential information with this third party. So in that case, this standard specify how, why, and what are the safety measures that we need to take in order for us to uphold privacy, okay, the standard for privacy and confidentiality. So this standard 4.06 specifically highlight that when consulting with colleague, okay, one, psychologists do not disclose confidential information. Okay, this confidential information that reasonably could lead to the identification of a client, okay, or patient, identification of research participant or other person or organization with whom we have a confidential relationships, unless we have obtained the prior consent of the person or organization, or disclosure cannot be avoided. Okay, and two, they or we disclose information only to the extent necessary to achieve the purpose of the consultation. So basically for better treatment planning or improvement or enhancement program. So this standard 4.06 should also be read together with standard 4.01, which is maintaining confidentiality. So basically, these standards requires us to do three main things to uphold or adhere to this standard. One, whenever we involve in consultations, we must not share or avoid sharing identifying information. Okay, information which if people know about that, they basically can deduce or they can infer who is or who are the organization. So psychologists must not disclose information during consultation that could reasonably identify a client, a patient, research participant, or organization. So this restriction applies to all forms of communication. Okay, whether it's oral communication, written reports, or electronic based communication. Okay, nowadays we have many platforms. Okay, you have messaging platforms that we can use to improve the efficiency of our communication, but you have to be aware that in those kind of platform you cannot share confidential information. So identifying information in this case not only about the name of a person or not only about the name of the organization, but it also include contextual details, okay, such as workplace, age, diagnosis, location, family structure, or personal events that may lead to someone to deduce who basically own the information, the identity of a person or the organization. Okay, so basically we should not share, or we must avoid sharing identifying information. And secondly, if is unavoidable, okay, is we must share the information, otherwise we cannot have a meaningful consultation. We must obtain consent from the client. Okay, obtain consent when disclosure is unavoidable. If identifying information must be shared to obtain meaningful consultation, we are required to obtain prior consent from the individual or organization. So we must explain the nature and the purpose of the consultation, and we must clarify who will receive the information, and we must document the process, okay, the process of getting the consent from our client. So these standards allows limited exceptions of sharing confidential information only when disclosure is unavoidable, okay, and only if it's permitted by law or ethically necessity. However, even in this kind of scenario, this kind of circumstances, we must make every effort to minimize intrusion of privacy, okay, intrusion of privacy of our client or our organization. Okay, so in this case, whenever it's necessary, we must limit the information that we disclose to others, okay, the information that we share with others. So we limit disclosure to what is necessary only. Even when consent is granted, psychologists must disclose only the minimum amount of information needed for the purpose of the consultation. Okay, this basically reflects the ethical principle of proportionality. Okay, basically we only share minimum information about people. Okay, the more information we share, basically the greater the risk on privacy and confidentiality. So for example, if consulting about treatment planning for a client with a certain mental health, say for example depressions, so describing clinical symptoms and therapeutic concerns should always be prioritized. Okay, we must not share unrelated biographical information, personal history for examples, and this should not be shared during the consultation. So what happens if we adhere to these three requirements in order for us to fulfill standard 4.06? So the implication of this standard basically inform us that when we involve in consultation, okay, we must remove identifiers whenever possible. Okay, if you are familiar with the process of publishing in journal, for example, so when the editor will request you to make your manuscript anonymized, meaning that there is no identifying information about yourself in the manuscript, no names, no salutations, no affiliation, and etc. So we make the case anonymous. Okay, we don't refer to a person by their identity. So if we involve in consultation, we use aggregate or hypothetical descriptions rather than personal information. Okay, and then we must use secure data transmission when we use electronic communication platform. Okay, this is to ensure that the information is not leaked to another party. Okay, we should also verify the qualifications of the other consultants. Okay, the person that we are discussing, that we are consulting, we must verify their qualifications and confidentiality expectation. Why? If they are qualified licensed IO psychologists, they should also aware about confidentiality and the risk of privacy here. But if not, then you cannot assume that they know about it. Okay, you have to explain as well. And then you have to reassess the necessity of disclosure. Okay, draw out the consultations, although you plan to disclose, but then you found out that it's already fulfilled your purpose, then you need to reassess. Okay, maybe you don't have to even share about the personal information or the confidential information. And lastly, okay, the implication of this standard 4.06 on consultations, we must always document, okay, properly record the consultation and disclosure, rationale and process. So failure to follow these requirements may pose a threat, okay, risk on ethical violations as well, maybe even more serious legal consequences, and may lead to harm to our client. Okay, so basically, so this standard 4.06 ensure that when we seek consultation, okay, we perform identity protecting measures, okay, to ensure that we do not pose any threat to our client. Okay, consent is required, okay, if the disclosure, the sharing of information is unavoidable. Okay, and shared information is strictly limited to what is necessary only. No additional, unrelated or extra information is shared with the other parties. So this standard basically reinforce our ethical practice by balancing our professional collaboration with respect for our client dignity, autonomy and confidentiality.